Well, good afternoon, everyone, and welcome to AEI, and welcome to our new wonderful facility. My name is Gary Schmidt. I'm a resident scholar here at the American Enterprise Institute, and I direct our program on American citizenship, which is sponsoring today's Walter Berns lecture. Just a brief housekeeping matter. So our format's going to be really quite simple. We'll hear the lecture, and then after that, we'll have a question and answer period that I will moderate. And upon the conclusion of that, we'll have a reception outside, wine and cheese, and so you can keep the conversation going. Thank you for joining us. I also want to say, for those watching online, thank you for joining us as well, but also I'm told that you'll be able to watch online and submit a question for consideration after the address. And what you do is you go to sli.do and enter the code AEIEvent. It's all very simple. Again, sli.do and enter the code AEIEvent, one word. Type in your name and submit, and we'll take your questions as we're able to do so. With that, I'm going to get off the stage and let Arthur Brooks begin the formal proceedings.
Thank you, Gary, and thanks to all of you. Welcome to AEI. I'm the president of the American Enterprise Institute, Arthur Brooks, and it's an honor to have you with us here today in this beautiful place. You may or may not know that this is one of the first events we're holding in our new headquarters. This is not a new headquarters. This building was built in 1917. But we've been in this building for about 10 days now. You can see a lot of it's very special, redone. The building was completely renovated on the inside. We couldn't touch it on the outside at penalty of death because that's how federal law works with respect to historic buildings. You can also see that we have a lot of ways to do events in new and creative ways. You can see it looks more or less like we got the old set from the Mike Douglas show up here. We're going to have a lot of fun in this building, and I'm glad to have you here for one of our very first events. And this is a very special event, to be sure. When you came into the building, I hope you noticed in the foyer there, it's a circular room, and it has sconces that have quotes from AEI greats, from people from the past, some of whom passed away, some of whom are still alive. But one that has special significance for us, of course, is that of Walter Berns himself, the man for whom this lecture series is named. And if you look on your way out, if you didn't see it on your way in, here's a quote that was simple, typical, and profound in the message that it gives. It really reminds us of the wisdom of Walter, what he gave us here at AEI. It says, citizenship, like patriotism, has to be cultivated. It can't be taken for granted. And indeed, it isn't here at AEI, which is why we celebrate this day in the annual Walter Berns Constitution Day lecture. This is the 5th in the series. We'll be having them for many, many years to come. The address this evening will be by the Honorable Michael Mukasey, no stranger to any of you. He'll discuss the topic Terrorism and the Bill of Rights. That is one of the most significant national security issues of our time, of course, and one that Judge Mukasey has been studying, speaking on, and working on for a long time. You know him as the Attorney General for the Bush administration from 2007 to 2009. Before that, he was the U.S. District Judge in the Southern District of New York from 1988 to 2006, where he was appointed Chief Judge in the year 2000. Currently, he's of counsel at a New York law firm and a frequent contributor to current issues on law and law enforcement. You see him on TV and writing in the paper a lot. He's the perfect person to be talking about this topic here tonight. He was awarded the Federal Bar's Learned Hand Medal for Excellence in Federal Jurisprudence, writing in no small part about terrorism. He presided over the trial, as many of you may know, of the blind sheikh Omar Abdel Rahman, who was responsible for the terrorism plots of the 1990s in the United States. And he issued new guidelines for domestic FBI operations in 2008, which helped consolidate the Bureau's rat's nest of investigative rules. It made it easier for us to understand what was going on in terrorism. And with that, given that impressive resume, you want to hear from him and not me. Please welcome Michael Mukasey.
Thanks very much, Arthur, and thanks to AEI for having me here. It's an honor to be invited to this podium, particularly considering those who've preceded me here. It's also a pleasure, and one of the most pleasurable features is the chance to say that I think that Walter Berns, for whom this talk is named, was the person with the deepest understanding of the U.S. Constitution, its structure, its meaning, and its purpose of anyone who has written or spoken on the subject in modern times. I should add that in saying what I just said about Professor Berns, I don't mean to diminish the importance of the late Justice Antonin Scalia, whose originalism brought a lot of lawyers and others in and out of government to a better understanding of the Constitution, and who wrote a book each on constitutional interpretation and statutory interpretation. But his intellectual strength was focused mainly on issues relating to courts and lawyering, and displayed mainly in the cases and controversies that happened to pass before the Supreme Court. Professor Berns, I learned, was not encumbered by a law degree. It's been said that the law sharpens the mind by narrowing it. And I think Professor Berns's books and essays are especially important today because the Constitution itself and the framework that it established is in danger of disappearing from the consciousness of the people who should be its principal custodians and defenders, and that is lawyers and government officials, including but certainly not limited to judges. Consider, for example, that there's hardly any law school in this country that teaches a course in the Constitution itself and the system of governance that it establishes. Rather, constitutional law consists of studying cases, mostly Supreme Court cases, revolving around one or another provision of the Constitution, involving only the Commerce Clause from the body of the document itself, and otherwise some of its amendments, mainly the 1st, the 4th through the 6th, and of course the 14th. Professor Berns himself made the revolutionary suggestion that law schools should include the study of the Constitution itself in their constitutional law courses, but the idea doesn't seem to have caught on. In fact, the author of one casebook on constitutional law, who heard that his book was criticized for including the text of the Constitution only as Appendix H, is said to have responded when he heard that criticism that he was going to cure that and make the Constitution more prominent. He moved it up to Appendix A. Unseriousness about the Constitution, which Professor Berns targeted in the title of one of his books, Taking the Constitution Seriously, has been so pervasive that when the then Speaker of the House heard that the Affordable Care Act was going to be challenged in court as a violation of the Constitution, her response was, "The Constitution, really?" accompanied by a rolling of the eyes in case anyone missed the condescension. Just as knowledge of the actual Constitution seems to fade, expressions of concern from both the left and the right over what is said to be unconstitutional behavior by the government seem to get constantly sharper. And in particular, as I'm going to discuss here, in response to measures the government has taken to safeguard the country in the face of a worldwide campaign of terror being waged by Islamists. One manifestation of that particular concern was the successful campaign by libertarian Republicans and liberal Democrats in Congress to end the government's practice of gathering what is called telephone metadata so as to better be able to track foreign terrorists. I'll also talk about that program a bit later, but the phenomenon has been widespread, and it's not limited to legislative efforts. One law school professor and dean has just published a book in which he traces what he regards as government infringement on a broad range of constitutional rights he traces it to what he regards as the Supreme Court's undue deference to the political branches, mainly the executive, and the refusal of the courts in general to exercise what he regards as their proper role. He condemns not only the Supreme Court, but also the Foreign Intelligence Surveillance Court, or Fisa Court. He criticizes that court not only for the outcomes it produces by giving the government what he argues is free rein to conduct electronic surveillance, but also for reaching results, at least at part of the time, in decisions that are themselves kept secret, thus creating a body of secret law. The criticisms of our counterterrorism efforts focus mainly on three topics: secrecy, detention together with the closely related topic of interrogation, and surveillance, mainly but not exclusively electronic surveillance. It's a regular feature of panels and seminars on the government's response to Islamist terrorism that what we must do is to strike a balance between safety and the liberties protected by the Constitution, and of course that studying the Constitution itself is essential to doing that. I believe that the Constitution actually has very little to do with these disputes, that we are faced here with a political and national security problem that's been constitutionalized in certain of its aspects, in part so as to avoid dealing with it. That in the process we trivialize the real Constitution, and that at some point we're going to have to pull up our socks and deal with this problem, or it's going to deal harshly with us. I think part of taking the Constitution seriously, as Professor Berns taught us we should, involves recognizing the choices it does not make for us, and that we therefore have to make for ourselves. Let's start with secrecy. The need for secrecy in pursuing the ends of government was something that was well known to those who wrote the Constitution and to those who first declared our independence. The First Continental Congress convened under rules that required that the doors be shut during the transaction of business, and that members keep deliberations secret until a majority authorized them to be released. The Second Continental Congress imposed an oath of secrecy on each member to be relaxed only when Congress gave its explicit permission. The Constitution itself was drafted under conditions of strict secrecy. In summertime Philadelphia in 1787, before air conditioning, the doors and windows were shut, the delegates sworn to secrecy. James Madison, the principal architect of the Constitution, recognized the obvious conflict between secrecy and democracy when he wrote that a popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. On the other hand, he also wrote that no constitution would ever have been adopted by the convention if the debate had been public. The body of the Constitution explicitly accommodates the need for secrecy. It provides that each House of Congress, quote, shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgment require secrecy. Washington himself fully understood the need for secrecy in gathering intelligence. He wrote in 1777 to one of his colonels that the necessity of procuring good intelligence is apparent and need not be further urged. All that remains for me to add is that you keep the whole matter as secret as possible. For upon secrecy, success depends in most enterprises of the kind, and for want of it, they are generally defeated, however well planned and promising a favorable issue. The Constitution, of course, built into the government a system of checks and balances between branches of the federal government and between the federal government and the states. But it provided little in the way of a mechanism, other than the power of the purse, for Congress to oversee and check the power of the executive, requiring only that the President report to Congress from time to time on the state of the Union. Here I think it's important to recall that the reason for the creation of the Fisa Court to oversee collection of intelligence was simply to provide yet another layer of supervision, not to open intelligence gathering to public scrutiny or to turn it into an adversary proceeding. It was simply to assure that the surveillance of those people protected by the Fourth Amendment, all people present in the United States and American citizens traveling abroad, was reasonable. The creation of the Fisa Court was certainly not constitutionally mandated. The only court provided for in the Constitution is the Supreme Court, which is given judicial power along with, as the Constitution puts it, such inferior courts as the Congress may from time to time ordain and establish. However, the very existence of the Fisa Court has led to demands that its deliberations be conducted under adversary conditions, which it is suggested is the main attribute of a real court, and open up to greater public scrutiny. Critics of the Fisa Court are fond of pointing out that the government has above 95% success rate in its applications to the Fisa Court, and concluding that that court must simply be rubber stamping the applications. Those critics do not consider the real reason for that success rate, which is quite simply that the National Security Division lawyers who prepare those applications are well aware that their main stock in trade is credibility, and who therefore prepare their applications as conservatively as possible and avoid aggressive requests so as not to incur the criticism of the court and thereby risk having applications generally subjected to more searching and hostile review, with the possibility that applications that should be granted may be delayed in the effort to assure that the court does not grant one that shouldn't be granted. Also, the process of securing approval is sometimes iterative. The government submits an application, the court raises one or more issues, and the application is scaled back or otherwise changed. The suggestion is that the court rubber stamps government applications is simply a grotesque distortion. Because the 1978 statute gave the judiciary a role in supervising the gathering of intelligence and did it through the creation of a court, some have used the existence of a court itself as a basis for a demand that the supervision be provided through an adversary process. After all, most court proceedings, at least in the popular imagination, involve adversary encounters between two parties. Some have suggested that the Fisa court is not a real court because only the government appears in connection with applications for authority to conduct surveillance. Of course, for the government to notify each target of intelligence gathering that such gathering is proposed, and then to permit each such target to contest the issue, would destroy intelligence gathering altogether and notify our adversaries and enemies of what we're doing. One proposal has been to create an office that will stand constantly in potential opposition to any application for authority to conduct surveillance and litigate the issue before the Fisa court. Apart from burdening each application, we should wonder in which branch of government this office would be located. Because its function is in essence executive, this would create the constitutional absurdity of an executive litigating against itself to no end other than creating the appearance of an adversary proceeding. Notably, the judges of the court themselves have said that they find this proposed office burdensome and unnecessary. In the same way, requiring that the work of the Foreign Intelligence Court be open to the public, or that decisions of the Foreign Intelligence Court be disclosed publicly, uniformly, so as to respond to the criticism that the court is applying secret law in secret, would mean that one of the main features of intelligence gathering, maintaining secrecy, would be compromised. Whether applications before that court are reasonable or not turns on the facts underlying them, and not on any insight that can be gained by examining the text of the Constitution or its amendments. The Fisa court was not called into existence as a matter of constitutional necessity, but as a matter of perceived, and I happen to think highly debatable, prudence. There is no reason why it has to be decked out to look like an Article III court with public adversary proceedings in order to fulfill the function for which it was created, which is simply to add the judiciary to the supervisory apparatus within the executive, as well as the intelligence committees of both houses, so that all three branches would be involved in monitoring the reasonableness of electronic surveillance gathering, sort of a Madisonian trifecta. This is not the traditional role of a court, or more relevantly, the constitutional role of a court, which is to decide cases and controversies. But it is pretty close, and it involves issues that could easily generate cases and controversies. The detection and interrogation of suspected and confirmed terrorists have also generated what purport to be constitutional controversies. So we're told that it's a violation of the Constitution to detain anyone without a trial, and that interrogation as well presents constitutional concerns, both in the means used to get the information and in the possibly incriminating effect of any information that is obtained. In fact, there's a whole range of situations, some related to wartime powers and some not, in which detention without trial is entirely permissible, so that the person or people detained do not cause harm to others or to themselves. In each of the wars that we fought, we detained at times hundreds of thousands of prisoners of war, some in the United States and some elsewhere, and none of them were tried. In fact, none of them were permitted even to file a habeas corpus petition. The Constitution's suspension clause permits Congress to suspend the writ of habeas corpus entirely when that is deemed necessary to protect public safety, such that people detained would not even have the means to challenge the lawfulness of their detention. Our criminal laws provide, when necessary, for pretrial detention of those who may be charged with crimes but not convicted, when necessary to protect public safety or to assure that those defendants will appear for trial. And detention of material witnesses who have been convicted of no crime and who stand charged with no crime is permitted in order to make sure that their testimony is available when necessary if they present a risk of flight. Aliens who face deportation may be detained, and the mentally ill may be detained to protect society or themselves. Pregnant addicts may be detained to protect their unborn children, and sex offenders who are found likely to repeat their offenses even after they have completed their sentences may be detained. All of those detentions occurring without offense to the Constitution. Many of these authorities, these detention authorities, predate the Constitution itself. So it's not that we started out with an absolute ban on detention without trial and have created exceptions over time. Some individual powers have expanded, notably detention of sex offenders. Others have narrowed, notably detention of the mentally ill. But they have existed over time without successful constitutional challenge. As to unlawful combatants, those who do not follow rules of war that were designed to protect civilians, as to them, it was permissible at one time to deny them any legal protection whatever. The laws of war offer combatants essentially the following bargain. If you wear a uniform so that you can be distinguished from civilians, if you carry your arms openly, and if you follow a recognized chain of command so that you act only on orders, so that your superiors can be held accountable for your conduct, and most importantly, if you do not target civilians, then you're assured that if you're captured, you must be treated humanely and consistently with your rank, and you may not be forced to divulge your side's secrets. However, you may be detained without trial for the duration of the conflict. As I said, at one time, if a combatant did not adhere to those standards, he received no protection at all. It was permissible to treat him, as it's put in an international law treatise that I have on my shelf, summarily, which is to say, to shoot him. In fact, there were Germans tried after World War II at Nuremberg and elsewhere for executing partisans who were acquitted of that charge because executing partisans who did not fight in uniform or carrying their arms openly was not a war crime. Current law still permits U.S. citizens who violate the laws of war to be treated just the same as non-citizens on what seems to me the entirely plausible theory that if they throw in their lot with unlawful enemies, they can be treated like unlawful enemies. However, the distinction between lawful and unlawful combatants appears to be wearing down, to the point where some have suggested that although those who follow all the laws of war may be detained without trial for the duration of the conflict, we should actually offer a better deal to those who violate all the rules. Rather than being held indefinitely, or at least until it's clear that they no longer present a danger, they should have the right to a trial in a civilian court with appointed counsel and the presumption of innocence, and the possibility that if acquitted of whatever crime they may be charged with, they will be released. In fact, one terrorist, a man involved in planning the bombing of the U.S. embassies in Kenya and Tanzania, nearly did just that. Ahmed Gailani was acquitted after a trial in New York of the hundreds of murders that resulted from those bombings, but he was convicted of one count of conspiracy to damage U.S. property, for which, despite the innocuous-sounding charge, he was sentenced to life in prison. Before he was tried, Gailani had been detained at Guantanamo, and although he had been charged before he was captured and detained there, his case was apparently supposed to be the thin end of the wedge to show that we can bring detainees from Guantanamo to the mainland and try them here with no adverse consequences. His near-total acquittal in New York somewhat undermined that gambit. We have captured and detained many people who in fact violated the laws of war, some of whom we have evidence against that's sufficient to charge them with war crimes. The defendants charged in the 9/11 attacks are a good example. Others of whom we do not have such evidence against, but who nonetheless present enough of a threat to our security that simply releasing them would assure that they return to the fight and inflict more casualties than they have already, even assuming that there's some jurisdiction that will have them. Of all of those detainees, some may have information that's still valuable, despite their long period of confinement. Information not simply about particular plots, but about relationships between and among terrorist groups, and even individual terrorists that can be used to help dismantle those groups and capture people who mean us harm. The Supreme Court has ruled that even detainees not charged may continue to be held. However, the current administration is unwilling to rely simply on laws of war detention, with the result that interrogation of newly captured detainees, when there are such detainees, and they're not droned, is truncated, and they are either turned over to other countries or charged in civilian courts. For example, when a defendant involved in the attack on our embassy in Benghazi, Ahmed Abu Khattala, was caught in Libya, he was held for 19 days aboard a Navy vessel where he was interrogated in an effort to get any intelligence he may have had. Now, I have no idea whether the government got anything of value from him, but 19 days is a ludicrously short time in which to get useful information from even a willing subject, and it does not appear that Abu Khattala was a willing subject. Intelligence gathering from human sources is usually an incremental process in which information is gathered, checked, new information is gotten, and the question is returned to the detainee, sometimes over a period of months, to obtain additional information. In any event, at the end of the 19 days, Abu Khatala was brought before a court, formally charged, and assigned a lawyer. That ended his use as an intelligence source. Of course, whatever information was obtained from him, as well as any leads from that information, may not and will not be used in connection with his prosecution. What we now have is some detainees held at Guantanamo without charges, some held with charges that are pending before a military commission, and still others held in U.S. prisons who have been convicted of federal crimes or are charged with such crimes and awaiting trial. This patchwork of detention is not a constitutionally dictated outcome, but rather a result of a series of political accommodations. Although I am describing this situation in the present tense, I certainly do not intend to absolve the administration in which I served from responsibility or, if appropriate, from blame. At the time we first responded militarily after the attack on September 11, 2001, it appears that great reliance was placed on World War II vintage authority in determining how detainees would be treated. Recall that even prisoners of war who followed the rules of war were held indefinitely and without recourse to the courts. And when two groups of German saboteurs landed on mainland United States territory, one group on Long Island and the other in Florida, and fatally for them, shed their uniforms, they were rounded up and on the direct orders of President Roosevelt were tried before a military commission convened in Washington, even though the civilian courts of the country were still open and functioning. They were convicted and executed, all within 3 months of the time that they landed, despite the claim of at least one that he was a U.S. citizen. Their convictions were affirmed by the Supreme Court in an opinion that was actually filed after they were already dead, the court having affirmed the convictions so as to permit the executions to proceed with opinion to follow. It was anticipated, based in part on that history, that the executive could set up military commissions to deal with detainees who would be charged with violating the laws of war and simply hold the rest indefinitely. However, as detentions lengthened, the Supreme Court has pared back that history mightily. It held first that the President did not have the authority to establish military commissions on his own, a gap that Congress quickly filled with the Military Commissions Act. And then the court held that even unlawful combatants are detained by the United States in a location that's outside the theater of war, they have a right at least to challenge the lawfulness of their detention in a proceeding that should resemble the rudimentary challenge brought in a habeas corpus case. Habeas corpus is a venerable right that actually preceded the Constitution and which the Constitution recognizes by restricting its suspension to situations where Congress determines that public safety requires it due to invasion or rebellion. However, the Constitution does not provide substantive standards that describe what conduct must be proved in order to detain someone as an unlawful combatant, and what level and type of proof is necessary to justify continuing to hold a prisoner as an unlawful combatant, and for how long. Interrogation techniques used on some detainees have been objected to on constitutional grounds, although constitutional objections have been secondary to the claim that the techniques violated the statutory ban on torture, which they did not. In any event, nothing in any clause of the Constitution provides even a clue as to what is permitted and what is not, when there is reason to believe that a detainee has information which, if disclosed, can save lives. The Eighth Amendment ban on cruel and unusual punishment has no application here because interrogation techniques are not applied as punishment, but rather as coercion to bring about a cooperative state of mind. The only hint of a constitutional standard comes from a line of cases that started with a case called Rochin versus California, and that bars the government from doing anything to a prisoner that, quote, shocks the conscience. Not a real rigorous standard, that, considering not only the range of sensibilities that lie under the thousand or so black robes on the federal bench, and the thousands more that populate the state courts, but also on the range of situations that confront law enforcement officers. Pumping the stomach of a prisoner may shock the conscience if it's done to retrieve evidence of a drug offense, as happened in the Rochin case. But later cases have made it clear that the standard is situational. So the same conduct might not shock the conscience if it were done to find the whereabouts of a kidnapped child or the location of a bomb. One thing the Constitution does do is to provide a response to those who argue that we should have a direct voice in the interrogation techniques that are applied in our name, as they like to put it. That answer is that the Constitution establishes a representative democracy, not a direct democracy. Decisions made by those who hold executive or legislative office are reviewable, if at all, at election time, not otherwise. Until creation of the Fisa Court, it appeared that there was enough protection for the Fourth Amendment's general command that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches shall not be violated, that there was enough protection for that in the warrant clause of that amendment, which provides that no warrant could issue except upon probable cause, meaning a showing of probable cause that a crime has been committed and probable cause to believe that evidence would be found in a particular place or on a particular person in order to detect it. Absent a warrant or a showing of probable cause and exigent circumstances that excused obtaining a warrant, evidence could not be introduced in court, and so a principal source of damage from unlawful surveillance could be avoided. However, after Watergate, it was felt necessary to subject even intelligence gathering to supervision, not only by the executive itself and Congress, but also by the judiciary, the Madisonian trifecta that I referred to before, so as to assure that there would be no abuse. The need for such assurance seems to have stemmed in part from a few lines in the White House tapes in which the president is heard urging that the Watergate break-in be concealed behind a claim that it involved national security, and another passage where he seems to suggest that if the president authorizes what would be regarded as an unlawful course of conduct, it is, by that authorization, rendered lawful. Now, I don't want to get into a long discussion here or try to defend the indefensible. But Richard Nixon was, after all, a lawyer, and a fairly serious one. So he may have had in mind a doctrine that does exempt the sovereign from the reach of criminal laws that are not intended to prevent harm or injury to a private citizen, although burglary and wiretapping are not within that doctrine. It may have been arguable that wiretapping for national security purposes might not have been within it, at least until Congress definitively occupied that field with the Foreign Intelligence Surveillance Act in 1978. The actual collection of electronic intelligence itself has incurred the anxiety of people who claim they are concerned about constitutional violations. Until last year, there was in place a program whereby the government collected what is known as metadata of calls in the United States, the record of the calling number, the called number, the date, and the time, the same information that telephone companies keep track of in order to generate a bill, which does not include the content of the call. The purpose for doing that was to permit the government, when it got word of, say, a telephone at a safe house used overseas by terrorists, to run the number of that telephone against the database of calls in the United States to see whether it had called or been called by any telephone in this country. The government could then focus on that telephone number and try to gather enough other information about the subscriber to apply to the court for a wiretap order under conventional standards with a showing of probable cause. That was the only purpose for which this database was put. There were fewer than 30 people at NSA who were authorized to query the database, and they could do so only after getting permission from their supervisors, and most recently from the Fisa Court. They were not permitted to engage in data mining or any other exploitation of this database. Nonetheless, opponents of the program mounted a successful scare campaign that subscribers' privacy was being violated. A scare campaign based not on what NSA employees did as they followed the rules under the program, but on what they could do if they broke the rules. This makes about as much sense as disarming the police because some officer might run amok and decide to turn his gun on a civilian. And yet a coalition of self-professed libertarians and self-professed progressives combined to terminate the program. They argued also that assembling data in this fashion violated the subscriber's Fourth Amendment rights because it amounted to a general search in violation of the Fourth Amendment's particularity requirement, notwithstanding that the records in question do not belong to the subscribers at all, but rather to the carriers, and that the searches of data in the hands of the carriers, assuming that they can be carried out successfully, are intended to be and are as broad as the search of the same data in the hands of the government. The result is that the government can no longer gather metadata itself, but must consult individual carriers, each of which organizes the metadata as it wishes, and each of which may simply stop maintaining it. There is now afoot a move to curtail the gathering information from foreigners abroad, who have no rights under the Constitution, by treating them as if they were protected by the Fourth Amendment. In essence, turning the Constitution from a document that protects citizens and residents of the United States into a treaty with the entire world. The wording of the Fourth Amendment itself provides no clue as to which precautions may be necessary and which unduly burdensome in order to preserve the integrity of the persons, houses, papers, and effects of citizens and residents of the United States. And if Congress chooses to extend protection to non-resident non-citizens, nor does it tell us how far to extend those protections. All of this would be of largely academic interest, if not for the fact that whether we acknowledge it or not, we have been for decades the main targets of a war being waged by a death cult. It didn't start on 9/11 or even in February 1993 with what we now know as the First World Trade Center bombing. It actually started back in the 1940s when one of the leading lights of the Muslim Brotherhood, Sayyid Qutb, an Egyptian working in the Egyptian ministry in Cairo, was awarded a traveling fellowship that was meant in large part to get him out of the country. And he chose to travel to Greeley, Colorado. When he encountered Western society in post-war Greeley, Colorado in the late 1940s, with jazz music, crew cuts, dancing, he is reputed to have walked in on a church social when people were dancing to a recording of Baby It's Cold Outside, and he was scandalized. He decided that Islam as he knew it would have to be eternally at war with such a society. He went back to Egypt and continued to agitate in the same way that in the late 1940s had gotten him a traveling fellowship, except this time in the late 1960s it got him hanged. Many of his followers left Egypt for Saudi Arabia, where Qutb's brother wound up teaching the spoiled son of a wealthy Saudi construction family, a young man named Osama bin Laden. And the rest, as they say, is history. To fight this ideology, it's going to take not only force, although it's certainly going to take that, but also support for those within the Muslim world who favor reform, and they are there. In 2014, President Sisi delivered a remarkable speech at Al-Azhar University in Cairo, the seat of Sunni learning and the venue for President Obama's 2009 outreach to the Muslim world. President Sisi addressed the Imam of Al-Azhar University, looking right at him and the other imams who were assembled, and told them that Islam, as being preached, was bringing death and destruction on Muslims, and urged them to put an end to it. He urged that curricula in Egypt must be reformed to eliminate the teaching that strict Islam must dominate the world by force if necessary, and that it is the personal duty of each Muslim to bring about that domination. The Imam, Ahmed al-Tayyib, followed up with his own speech, which he delivered not in Cairo or in Chevy Chase, but in Saudi Arabia, arguing that Muslim young people were being misled and ruined by an erroneous interpretation of Islam. Although latest reports from Egypt indicate some backsliding from that position by those in control of Al-Azhar University, the government itself apparently remains committed to the reform effort. There are those in our own country who preach the same message, but they are not the focus of the government's outreach, which has gone instead to organizations like CARE, the Conference on American Islamic Relations, and ISNA, the Islamic Society of North America, both of which are affiliated with the Muslim Brotherhood. Now, the Muslim Brotherhood sounds like a fraternal organization, the Elks or the Rotary Club. It's not. The slogan of the Muslim Brotherhood from the time of its founding until now has been, Allah is our objective, the Prophet is our leader, the Quran is our law, jihad is our way, and dying in the path of Allah is our highest hope. CARE, as a matter of fact, was named as an unindicted co-conspirator in the terrorism financing case against the Holy Land Foundation, the largest such case ever tried in the United States. They are the people who are regularly invited to the White House and recognized as representative of Muslims in the United States. As recently as last week, the Secretary of Homeland Security attended and spoke at the annual meeting of ISNA, the Islamic Society of North America, and thereby credentialed that organization. He waved off any criticism of what he did, saying that he was merely reaching out to a large audience of Muslims. His blindness to the secondary effect of his outreach is stunning. Imagine what the reaction is bound to be for the average Muslim resident of the United States when high government officials confer on ISNA the mantle of respectability that comes with being wooed by such officials. How likely do you think it is that such an average resident would reject the Council of CARE and ISNA and opt instead for the teaching of those who believe that those organizations are intent on subverting the values of this country? Not very likely at all. No doubt the claim would be made that if our government favored reform-minded Muslim groups and enhanced their credentials by engaging them rather than organizations like CARE and ISNA, the government would be picking winners and losers in a religious dispute and thereby violating the First Amendment's Establishment Clause. The point here, however, is not a matter of religion, but a matter of politics and national security. Is it lawful for the government to favor, for political and national security reasons, people who accept our constitutional system of governance and to oppose those who don't? It was entirely permissible to do that during the Cold War when our adversaries were communists who wanted to subvert our constitutional system and replace it with a totalitarian system. In fighting this war against such an enemy, one that thinks that not only dancing, but the very idea that people can choose their own government is a sacrilege, perhaps we should follow the example and take the advice of our greatest president, certainly our greatest lawyer president, who said this in 1862 about how to deal with an unprecedented crisis that threatened the existence of our country at that time. He said, "As our case is new, so we must think anew and act anew. We must disenthrall ourselves, and then we shall save our country." Make no mistake about it. The ideology that motivates the Muslims who are at war with us is a totalitarian ideology. It rules every aspect of life, economics, family law, whatever. It transcends allegiance to any nation state. Does this ideology's use of religious symbols, its call to a god and to a prophet, its reliance on a book, does that mean that even to the extent it trenches on politics and seeks to impose obligations on non-Muslims, and even to the extent it endangers our national security by encouraging Muslims to commit violence, do the hallmarks of religion mean that we can't fight it the same way that we fought other forms of totalitarianism? Do the free exercise and establishment clauses of the First Amendment tie our hands and prevent us from doing that simply because this ideology can claim to be rooted in a religion? The answer to that hasn't yet been definitively written, at least not in a case or series of cases. And no doubt if we try, there will be cases, just as there have been cases about intelligence gathering under the Fourth Amendment and cases about detention under the Fifth. But if we take the Constitution seriously, not just one or two of its amendments, but the political architecture it put in place for a government that can, among other things, preserve the state and protect its citizens, if we take that Constitution seriously, maybe we can fight the ideology that I've described in the way that I've suggested in order to save the country that the president I quoted a moment ago called the last best hope of earth. At least I think it's worth a try. Thank you.
Or here's fine too. So we have a few minutes for questions. And again, I remind folks watching via the internet that if they can send questions to us, again, through, it's sli.do.com and then AEIEvent, one word. We don't have much time, but Judge Mukasey has agreed to take a few questions, so feel free to ask right here. Wait a minute, I'm sorry. Wait for a mic, identify yourself, and really, 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 really do ask the question. Mike over here, right here. Yeah.
Hello.
Hi.
Sorry, that's loud. I'm Kate Bowman, and my question for you today concerns gun control. Many of your points defend the violation of specific constitutional rights to protect and preserve the safety of the general public. However, many Conservative Party members, while pushing for the allowance of these specific exceptions, like you mentioned for interrogation and detainment, consistently insist that the Second Amendment must remain untouched, even though gun control policies will protect the general public from both domestic and international terrorism. How are these two proposed exceptions different in nature and response? Thank you.
My point, I thought, was that what I've indicated is that these are not exceptions to any constitutional barrier. What I've suggested, what I've talked about, is not that we make exceptions to constitutional rules in order to deal with terrorism, but that we essentially stop using the Constitution as an excuse for not taking actions that it permits us to take. The Second Amendment, as interpreted by the Supreme Court, is not without exceptions. Nobody has ever been allowed to own an automatic weapon, and still isn't. Concealed carry laws are perfectly constitutional, as far as I know. There's a host of restrictions on the Second Amendment, but what the Second Amendment cannot control is the right of a citizen to own a weapon under appropriate conditions, so long as he's not a felon and so forth. So I don't understand there to be any inconsistency at all.
Please, right here.
Thank you very much. My name is Raghubir Goyal. I'm a journalist at the White House with India, Globe, and Asia Today, and I was during President Bush there in the White House. My question is that, first of all, my congratulations to AEI for this new building. And my question is that today we face the same question in the White House, that after 15 years of 9/11, 15th anniversary, and 5th anniversary of killing of Osama bin Laden, so where we go now, ISIL and different names now, is this Osama bin Laden's, all these coming back after his death? What is the future? Where do we stand after this? Thank you, sir.
The answer to that question lies outside this room, and I would suggest to you outside this country. But to the extent that it's within this country, yes, the phenomenon we see today has the DNA of Osama bin Laden all over it, both in the direct relationship between ISIL and Al-Qaeda, and in the ideology that they share. The point is what we're going to do about it. We can do two things. Number one, we can defend ourselves intelligently with all the means at our command, but when you're playing defense, you're losing. And secondly, we can encourage within the Muslim world those elements and those people that favor reform, and there are such. That was the point I tried to make at the end, and that we shouldn't be ashamed to do it. We shouldn't be embarrassed to do it, and we certainly shouldn't credential the people who defend those who espouse that ideology, like CAIR and ISNA.
In the back of the room, Frank.
Thank you, Judge Mukasey. Frank Gaffney with the Center for Security Policy. Great to see you. Wonderful address. Thank you very much for it. One of the items that might have appeared perhaps in a longer speech, but that I'd ask you just to quickly address, is the other tenet of the Constitution that seems to be under assault at the moment, namely freedom of speech, and the extent to which we are being told that one must not give offense to some of the people who you've just described as our ideological adversaries. Would you address this point and how that line can and should be drawn?
This may be the subject of another speech that I'm going to give at a future time. But my own view is this is an extension of a phenomenon that started back in late 50s, early 60s, when people who lost elections began litigating issues in court and discovered that you can lose an election but win an issue in court and prevail that way. That has now extended to prevailing by declaring orthodoxy and punishing people who don't adhere to it, to the point where I don't know whether this is going to be brought up or whether it has been brought up. I know Andy McCarthy, our mutual friend, has written about it. One of the candidates for president actually espoused the government using shaming techniques against people who violate orthodoxy by calling those people out for failure to adhere to politically correct positions. She did it in an unashamed kind of way and urged people in her audience to do that. That's what we're experiencing today, and I think that the pushback is something we're also witnessing today, and that pushback has to come not only from people who are voting, but people who are speaking and writing. If
I can be the immoderate moderator and ask you a question. you ended by talking about sort of made references to the ideological battle with communism after World War II, and of course then, at least initially, there was concern that one could take speech seriously in the sense of certain kinds of speech that challenged the very that challenged the constitutional legitimacy of the Constitution was grounds for criminal indictment. Of course, that's
I don't know that the speech alone was. I mean,
well, it was certain kinds of speech, but you didn't have to sort of be directly sort of inciting people to illegal activities, and then the court changed that. What I'm trying to get at is this difficulty one has dealing with online incitement by Islamists, and the degree to which the court's rulings on free speech have made it more difficult to address that unless and until there's actually sort of almost imminent criminal activity.
yeah, I mean, it's a knotty problem. There's a lot, though, that the government can do by way of messing with those sites. And I will tell you that there are conflicting views even within the intelligence community about that, because they feel to some extent that the existence of sites like that is valuable in the sense that it allows them to track people, to keep track of what's going on in chat rooms and so forth. It's a tough problem, but I don't understand there to be any real restriction if people were of a mind to do it to fighting that directly through interference, electronic and otherwise.
A question I'm going to try to sort of shorten the question, but a question from online from Thomas. Basically, it's a question about what would it take to step back and put in place both a more effective and responsible oversight system. What kind of cultural change do you think would be required to actually either change things the way they're done now, or return to some earlier ideas about how you think about, as you point out, the Constitution actually does address these issues?
Oversight system, you mean relating to intelligence gathering?
Yeah, intelligence, both from Congress and from the courts.
Look, the committees of Congress are supposed to exercise oversight. They have witnesses in from the intelligence agencies regularly, and they have them testify in closed session, and they are permitted to explore whatever they have to explore. Some of them, regrettably, don't have the discipline to get the job done. I mean, you watch, for example, the questioning at a House hearing. They go in 5-minute tranches. That doesn't get you anyplace. It used to be that congressional hearings or congressional committees had a chief counsel who, remember Sam Dash in the Watergate hearings, who questioned at length and pursued lines of questioning. They don't do that anymore.
I would say, except as a former staff director on the Senate Intelligence Committee, I would say that Senator Biden, now Vice President Biden, never took 5 minutes. It was always much longer than that. So,
right, but it also was never a question, was it?
No, actually, it was always quite remarkable. There would be no press in the closed hearing, and somehow it would still turn into a speech. But anyway, please, in the back. There's Mike, right?
Yes, my name is Alan Palmer. I'm a retired lawyer. Your address assumed the relevance of rules of law dealing with war. You used the term war when you said, I think, that the current war, the one you rely on for your analysis, began as early as the 1940s. It's a strange war, isn't it? Because it's a war on a concept, as it's typically referred to, a war on terrorism. And are you suggesting that Islamists could have been detained during the decades between the 40s and 2001? And finally, how long is this war going to last? Do we have the slightest clue about when the precepts you're endorsing might terminate?
Well, let's take it in order in which I can remember it. Number one, you said the war started in the 1940s. We didn't start it, okay? It began, although we were not aware of it, in the 1940s. Its first manifestation in the United States was, I think, in 1980, when an Israeli politician named Meir Kahane was assassinated in a ballroom in New York, and it was felt at that time to be the lone act of a lone gunman. It wasn't. It was the same group that in 1993 later bombed the Trade Center. You say it's a war on. It's not a war. It's not a war on a means. It's a war that is being fought by people against us. That we have an obligation, I think, to our own survival to counter in any way that we can. Obviously, it's not World War II. There are obviously many differences, but there are similarities as well. And to say that because somebody dies as a result of an unconventional or a war that somehow doesn't fit all the definitions of war, it can't be treated as a war. I would not want to have to make that point to the people killed in the Trade Center, or to the people, or to their relatives. That was just as much an act of war as any that's ever been committed. And how long is it going to last? It'll last as long as the danger continues. I mean, when the Germans marched into Poland, they didn't come with little pieces of paper that said, "Don't worry, this isn't going to last past 1945." We didn't know how long it was going to last. We didn't know how long it was going to last when we took prisoners. We were going to hold them for the duration, and we did.
We have time for one more question, so gentleman right here.
Just one additional point. There's also no need to hold people indefinitely. You hold them until they're no longer a danger, and that can be assessed on a regular basis. At least an attempt can be made to assess it.
Sir, thank you for your remarks. My name is Conrad Trisky. I work for the State Department. Like most people who aren't lawyers, my understanding of my civil liberties as a U.S. citizen is based on a foundation of civic classes and of a layman's reading of the Bill of Rights and the Constitution. And indeed, one could argue that for many Americans, the elegance and the simplicity, and most importantly, the accessibility of these documents is the foundation of their understanding of their civil liberties. And in your remarks, you noted that many of the perceived violations of civil liberties in the wake of September 11th were, upon closer reading of the U.S. legal code, not perhaps violations. How do you safeguard the American people against the slippery slope argument that the rights that they believe they have were, upon closer reading of U.S. law, not theirs to begin with? Thank you.
Don't know that I said that, but I will tell you that what protects the rights, your rights, my rights, and the rights of everybody in this room is not principally the Bill of Rights. Because if you want a real Bill of Rights, go to the Soviet Constitution. It protects not only freedom of speech and freedom to assemble. It guarantees, or guaranteed when it was in existence, shelter, food, all medical care, all sorts of things. It wasn't worth the paper it was written on, because the government that Constitution set up was controlled by one party. The protection for our freedoms doesn't lie in the Bill of Rights. It lies in the structure of our government and the fact that each acts as a check on the other. That's the real source of the protection.
I would say we're going to conclude now, and I would just say that's something that Walter repeated over and over and over to his credit, and obviously to its fundamental truth. But please join me in thanking Judge Mukasey for a wonderful presentation. And again, after we adjourn, there'll be refreshments in the hallway. Thank you.